Okay, so everyone can hear me and see me. Okay, chali. So, it was a very good paper, this means. So today I will discuss only paper one, right? And then in a day or two, we will go with paper two. Okay. Now, a lot of people here who are already student, right? Either in the test series or in the foundation batch. Yeah, few of them are here. Okay. No problem. That doesn't matter. So let me, sort of share with you the question paper first, and then, individually discuss one by one the questions. Okay. How to write those answers, we will discuss in very brief how to write those answers and the repeatability of it, right? Most of the time, I could see that almost 90% again this time was repeated. Now, as is the case always, the test series that I take, some of the copies also I will show. Most of them I also give the repeated questions in test series, right? So this is also the same thing happened. Lot of question which was in the test series came directly here in the exam. Now that is not to boast that I have a connection with UPSC. That is not the case. It is merely simply predictability that law optional offers. That more or less the questions are the same. Okay, so that is how it works. Okay, Chalit, let us again go through the. Let me show you the screen. Yes, all of you can see the screen. Yes. Okay. Okay. Cherry. Now remember that the question number one that we had this year is, where did the Constitution of India vest executive power with respect to the subject matter in concurrent list, which both union and state have legislative power? Explain. Now this question, if you remember, we have a specific provision in our constitution which says by default, by default, the executive power of the concurrent list lies with the state unless otherwise provided by the parliament, right? For an example, if there are very old law and that law says, okay, so and so is a central law, but the state, the pre-constitutional state, is exercising some executive power in that particular law, that will be continue to be governed by them until unless otherwise provided, right? So there is a very specific provision in our Indian constitution. Now, how to approach this question? Palak, ये question, right? This is again a very easy and very simple question with regard to subject matter, and also you could have written about repugnancy. Okay, what will happen in the case of conflict? Okay, so very 10 marker. Simply explaining the provision with regard to executive power and how executive power is coextensive of legislative power, and what specifically happens in the case of concurrent list, right? So simply talking about that would be sufficient for that particular question, right? Not very a tough question, quite an easy question. Okay, now let us come to question number 1B. It says, it is often said that L. Chandra Kumar, Supreme Court, is a rational deterrent with regard to administrative tribunal. Now, last year there was a question of tribunalization of justice, right? Now, remember, whenever there is very question of administrative tribunal, like this year, if I remember correctly, this Palak is the same Palak Jan which is here online, right? You are writing means this time, you written means, okay, or someone else. So that doesn't matter. So one of the questions that I asked this year is that why this tribunal is a problem. The intention was that what happened, L. Chandra Kumar said that, see, you cannot waive Article 226 jurisdiction of the High Court. Now that led to a situation whereby it doesn't matter what the law says with regard to that tribunal. Like NGT, it says okay, the appeal shall lie in the Supreme Court. Doesn't matter what the law says, but the appeal will lie to the High Court because 226 is a basic structure that has created effectively a four-layer mechanism. After NGT, yeah, any NCLAT also, you cannot directly go to the Supreme Court. You will have to go to the High Court. High Court can issue writs. Okay, so that 226 becomes a problem. That 226 becomes a problem. Okay, so that was the question. I had also asked this because this was not, it was in debate a lot. Okay, why tribunal is getting a problem, right? So obviously not the exact same wording of the question, but the answer remains the same. KL Chandra Kumar has effectively created a four-layer system instead of a three-layer system. Okay, especially in the case of tribunals. Okay, similarly, question number C, this was quite in news. Decided cases power to consult the Supreme Court, right? So I have asked a question, it is subject to misuse, how it can be misused, right? So political question can be determined in that manner. Sometime instead of going in the way of appeal, you ask for an opinion which becomes binding. Like in the appeal, Supreme Court refused to hear that appeal, but in the case of asking for an opinion or advice, Supreme Court will not refuse it. Okay? So that becomes a sort of a backdoor access to the Supreme Court by the judges. Okay, so that basically the criticism has to be written. Similarly, Article 21 question 1D. I have asked right to suicide is included or not in our test series, but they indirectly asked right not to live. Now remember, most of the people also did mistake also in the test series also. See that right to live, not to live is not provided. What we have in Article 21, basically it says, see, you have a right to live with dignity. So you can refuse a treatment which is undignified. You can refuse a treatment which is undignified. And for that, you can pass an advanced instruction. Right? So there is no right to suicide. Okay? That is something very important. Now, similarly, if you remember, those who are student, right, must have remembered that I always explain that there are two concentric circle about right and freedom. Freedom is much more larger. It means if a freedom of speech, it also includes freedom not to speak. But right is not that large. It is mostly in positive. So right to do something does not mean right to not do something. Okay, so that is why our Article 21 is right to life. It is not freedom of life. Okay, so that part could have been explained, and then judgment with regard to passive enthusiasm. Okay, 1E, again a question which is very typical. Last year also, in fact, last year test series, not this year test series. Last year test series, if you look at some of the toppers copy online, you will find exactly same term I have used. It is more structural than actual. Its application is not possible. Rigid application is not possible. Okay, this is again repeated question every time they ask it from the separation of power topic. This is the only question they ask most of the time. Okay, so again, very repeated. You have to talk about classic concept of separation of power and then how Indian constitution dilutes it. Okay, if you remember, if you have any of you have attended the last discussion, I have also talked about how you can make three sort of table column writing executive power, judicial power, and legislative power, and then write that how it is diluted individual. Okay, so that could have been done here also. Again, very repeated question. Let us come to the next question. ये समझ में आई बात? Yes, everyone. Palagacha, you are a different person. Okay. Teja, Ishauro, Priya, getting my point? ये बात समझ में आ रही है आप लोग को? Are you getting this? Okay, okay. ठीक है. चलिए, so let us come to the next. That is with regard to article, question 2A. Again, very easy question. Privileges, we had a Sita Soren judgment, so I was also expecting this question to come this time. Okay, article 105 and how. Because in Sita Soren, they very nicely talked about what is the meaning of the scope of the word, something which is, the privileges always apply to the proceedings of Parliament. Now, what do you mean by the proceedings of Parliament? Right? So, initially, in PV Narasimha, the court said that the proceeding include something which is connected to the proceeding very distantly. But in Sita Soren, they narrowed the scope of the meaning of the word proceeding and said that no, only which is actual proceeding, right? It means there must be an actual proceeding, it must be connected, then only the privilege will apply. Okay, so that is why this question came again, a current affair. It was discussed in that weekly current affair, as well as I think that consolidated current affair that I gave every year before mains. In that also this was covered. So again, a very easy question. Now this to be every time. See, I always tell that there are fundamental rights. There are three aspects, four aspects they ask question for. First aspect is substantial fundamental right. Article 14, 15, 16, all those. Second is Article 12 and 13. Okay? And third is relationship between fundamental right and DPS. Now remember that substantial part hardly question comes is of 10 or 15 marks. Like in this paper itself, there is only one question from substantial fundamental right, that is Article 21. Nothing else. Now think about it, very practical point of view. How do you, which part do you think is very tough to read? Article 12, 13? DPSP and fundamental right difference and the substantial part. Now, if you remember, that substantial part is so much, right? It takes entire of your total semester to read. Like in that is why in the mains, the foundation batch, I always tell, even in the test series, who comes at the last moment said what to do, leave the substantial part. Hardly 10 to 12, 15 marks question comes from substantial part. ये बात, keep that in mind. That in the fundamental right topic, the substantial part, hardly 15 marks of question comes, or maximum 10 marks, not more than that. The rest of the question comes from relationship between DPSP fundamental right or sometimes fundamental duty also, and Article 12. Okay, now Article 12, 13 can be read in 2-3 hours. Relationship can be read in 2-3 hours. Substantial will take you 3 years. Right? Not 3 years exactly, but at least 3 months to read, right? Each and every section in detail. This point, keep that in mind. Those who are, aspiring to read for the next year optional, keep that in mind. In fundamental right, three aspect is there. Just focus on 12, 13 and relationship part. Okay. Now, how this relationship part could have been handled? Remember, here the question was how both of them is trying to achieve the same objective and talk about the law. So you have to talk about different DPSP and the law as a consequence of that DPSP. Like benefit for women and children. So there is, prevention with regard to abuse, selling or buying of children. Similarly, with regard to minimum wage act for the downtrodden section of society, equality, minimum wage act, right? So what you could have done, you could have simply pointed, see, this is the DPSP and this is the corresponding law. Okay, this is the DPSP and this is the corresponding law, right? That was the question. Illustrate which have been enacted to implementation of DPSP. Okay, so quite simple. Hundreds of Manrega, even though not exactly a law enactment of the parliament, but still can be said to be, as a directive which is trying to implement Article 39. Okay, 1D. Okay, so 2C, Constituent Assembly laid down the facile procedure of amendment of the Constitution. Do you think the doctrine of basic structure significantly limits the amending power? That is something again I have asked this year. See, in Article 368, there are three type of questions. Remember, first is from the Article 368 itself. It's criticism. It has become more than the Constitution itself. It has sort of overtaken the judicial activism to the extreme part, subverted the parliament, the criticism aspect. Second question in the case of your basic structure comes on the evolution of basic structure. Keswanand Bharti, how all the Sankri Prasad and all this. And third question comes exactly with regard to what is the subsequent development of basic structure. So there's only three categories in which you get the question. Right? Now in our test series, I ask at least two of them. Like this year, I have talked about criticism. Judicial activism, the extreme form of judicial activism is Keswanand Bharti doctrine coming. Now, this question obviously not has been given in the same aspect, but the demand of the question remains the same. They have literally overtaken the amending power or diluted the amending power. Getting my point? Now, in that, basically, you have to write a GS type answer. Yes, it has done so. You take the view, slightly helping the executive itself. Okay. Acha, Matri. Okay. You are the student, right? Same. Okay. So this is again the question, Matri, if you remember, I told you also. It is the the three different area from where the question comes, right? It is about criticism. Okay. Chale, let us come to the 3A. It will not differ, right? Simply you have to give the examples here with its case law. That's it. Otherwise, if there is a GS type question, you will have to write the GS type questions. Okay, 3A. It says in a democratic society, a review of administrative action is soul of the without it, democracy and rule of law cannot be maintained. Exam. See, philosophical line. But what is the essence of the question? They are basically asking you what are the grounds of judicial review. Okay, so you leave all the wordings of the question that they have talked about, but you have to simply focus on the grounds of administrative action, judicial review. Okay, procedural grounds or substantial ground. In that, in between, you could write, okay, this, if it happens, it is a travesty of justice. If it happens, this is travesty of justice, right? So simply you have to, with new words, each ground you have to somehow connect with the question with regard to it is against the democratic belief, it is against the democratic principle, it goes against the ethos of democratic structure in India. So some time of philosophical line, but mostly you have to talk about ground of review of judicial administration. Okay. Excellent. Okay, 3B, examine the provision. Acha, one more thing. This year, there was only 3 pays given for 20 marks. Okay, so after exam, I got 2-3 panic calls कि सर तीन ही पेज थे, right? Doesn't matter. ठीक है, सबके पास 3 पेज थे. So इस बार, this time when I will take this test series, I will, give you 3 paper only. Yeah, only paper. Understood. I know only in paper 2, it was only 3, paper. ठीक है, so don't worry about it if you have a doubt. Practice करेंगे आप 4 का ही, ठीक है. Who knows next time? मुझे तो लगता है इस बार printing error था. That's why they gave only 3. ठीक है, otherwise, it would have been an issue. Okay, now let's come to examine the provisions under Indian Constitution that authorize Parliament to legislate on subject matter in a state list in the 7th schedule, right? So this was not a question of concurrent, but this was all those national security, 2 or more states requesting them, in the name of pursuance of the international treaty. ठीक है, when national emergency is in force, right? So it means you have to not exactly write the division of legislative power, but the exceptions where the state list also the union can legislate, right? So you have to individually talk about those articles and the case laws. One case laws would be sufficient for that. Okay. Let us come to question number 3C. It says it is significant that the state shall secure operation of legal system to promote justice, examining the provision of the Constitution and Legal Service Authority Act, right? So I passed a note, if you remember, the basic feature of the Legal Service Authority Act. Now, this is again one of the question which actually answers this question number 2B. This is one of the directive principle of state policy. Okay, and this is the consequent law which is for the purpose of implementation of that directive principle, right? So actually you can cite this question as an answer to the question number 2B if you think about it, right? Now what is the provision? So there are four major provision if you remember correctly. First is three-tier legal service mechanism would be there. They will try to educate women and children. Certain category of people will receive free, right? And then there is a concept of lok adalat and permanent lok adalat. So basically, you have to write the feature of the Legal Service Authority Act. But in what you have to do, you have to connect every feature that is ensuring access to justice. You have to write in every feature that how it is ensuring access to justice. Very easily, as a law student, you can mold and write it down. Again, a repeated question, right? It is not a different question. Examining the power of governor to so and so, right? It is two very major case. Can anyone name? Yes. The question to I have asked here also. Yes, Maitri will tell me what are the two important case here. Governor ke liye. We recently happened in Tamil Nadu. Anyone? For the pardon reprieves. Two very important case here. And there was a governor in Andhra Pradesh also who wrote, they were good Congress workers, so that should be given. Yes, that is again very good. Other case that I am talking about, the state of Andhra Pradesh. What is the first name versus state of Andhra Pradesh? No. Ipuru Sudhakar. Very correct. Very correct. Ipuru Sudhakar. Very good. That is very important. Chal. Now let us come to the next question. That is 4B. What is the significance? Basically, it is talking about what happened, what are the changes that was introduced after 44th Amendment to say that how the emergency provisions should not be misused, right? So all those Parliament must be called if 10% of the members say so, must be approved, automatic dilution would be there. Similarly, there's one very specific provision, if you know, I don't know whether you know or not, but every time, suppose a notification comes under 352, right? Now that says ki there is emergency. Now the suspension of the enforcement of fundamental right, there has to be a separate notification for that. Automatic नहीं होता है. ठीक है, like there is a notification कि okay, so and so fundamental rights shall be suspended or enforcement shall be suspended for the time being. So for that, it doesn't happen automatic. There has to be notification for that also, right? So either in the main notification providing for emergency, you write ki so and so is suspended, right? Or you have a separate notification. So that legal point must be mentioned here. Okay, that was introduced by this 44th Amendment. Yes, is this point clear? But don't get confused. If in GS they ask you कि they get suspended, the answer is yes. ठीक है? Don't say कि नहीं automatic होता है. वहाँ पे sometime law people get less marks. They start to think much more, reading between the lines in the case of your GS paper or that PYQ. Not that prelims. Okay. Now, Lokpal and Lokyukta have roots in Indian governance culture. Explain how so and so ensure transparency. Now, see, I've told you also multiple times. Just don't focus on the prelude. This is basically the question. This is basically the question. Yes, actually, very correct. That is why I said suspension gets, its enforcement gets suspended rather than the right itself. Very good. Okay, right now, so here again you have to write the basic features of the Lokpal Lokayukt Act, connecting them with thus ensures transparency, thus leads to more accountability, right? So 1122 line, connecting each features with accountability and transparency. That's it. Okay, so again a very typical easy question. There's nothing wrong with that. What happened? Give me a minute. Give me a minute. Sharing again. Yes, can you see the Can you see everyone? Any law that restricts enforcement shall be expressly linked to emergency. Huh? You can. Okay. Now let's come to part B. Again, last year also very typical question. Someone has simply talked about this and talked about what are those. To this Maitri, I think we were talking about your copy, day for study itself, right? I was talking about this very question. बताइए आर्टिकल 51 में क्या बोला था मैंने? नहीं, can Maitri tell me? कि आर्टिकल 51 uses the word armed attack. ठीक है? Now, armed attack has two set of jurists. One set of jurists says that there must be an actual armed attack. And second set of jurists says that no, it can be perceived armed attack. So that becomes a preemptive self-defense. Yes, very good, very good. तो देखिए कल डिस्कस किया, आज the same question came very easy. I mean कभी डिस्कस किया होगा. Okay, similarly, come to question number 1B, World Parliament. Basically, you have to criticize. Now, see, last to last year, the same question was in 20 marks. Right? Here, the same question is in 10 marks. Here, the same question is in 10 marks. So, you have to simply limit your, and this is again GS type. What you can do here, maximum, is that you can, cite relevant articles of the UN Charter. Okay, bracket mein name of the article. That is what maximum you can do. Otherwise, it is really a GS type question, and you will write GS type questions along with, live examples. That's it. Nothing more. Similarly, theories of state succession, rights and duties arising out of state succession, right? Now remember the two very important points. State succession, there are two major theories. One is clean slate and there is continuity. Now, what kind of right and duties will come will depend upon what theory is followed. Like in the case of colonial treaty, clean slate is followed. Now, in the case of commercial agreement, continuity is followed. In the case of boundary agreement, continuity is followed. So we have to write this, and along with the relevant example, or sometime you can literally talk about the convention's name ki so and so provides for this. Okay. Again, similarly, sometimes there's a question on a state and state succession and government succession. Okay. So that is also keep in mind. How does Rome Statute of International Court defines crime against humanity? Now this is something where Article 456 of the ICC Charter. Now here they have talked specifically about the definition of crime against humanity. Now, what to write? The definition of the crime against humanity in ICC charge is of 2 pages. More than 500 words. So simply writing that definition is more than sufficient for this answer. Getting my point, right? So it is not something whereby you have to write any case law or anything. Okay. What is contiguous zone, and discuss the Indian position on it. Again, very typical question. Like every year I ask this question in unclause. In unclause, this basically there are 3 sections to study. First, different zones, rights and duties. Second is with regard to equidistance, how the zones should be delineated. And the third is basically your dispute resolution mechanism, ITN, International Tribunal of Law. Right? So there are 3 portions from where question comes. So what you can do, who will study, that simply make a table and talk about zone, and here rights and duties of coastal state, rights and duties of non-coastal state or a third party state. Simply write that. Okay, and that will answer all your questions related to any of the zones of the international water. Okay, very simple. Chali. Now let us come to question number 6A. Now 6A is basically chapter 6 of the UN Charter, which talks about Pacific settlement of dispute. So we'll start with Article 1 and Article 2 of the purpose and principle of the UN Charter, that how it is one of the primary responsibility. Then you will go into detail of Article 33, 34, 35, which is in the chapter 6 of the UN Charter, which talks about that how United Nations will maintain international peace and security. Okay, first they will recommend this, then they will ask the Security Council. Security Council might do an investigation and send it back. If Security Council has taken cognizance, the General Assembly will not inquire into it, right? So all the provisions of Article 33, okay, that will be more than sufficient. In fact, I told you also that with regard to Security Council, the reason of failure is most of the time veto. Okay? So the second part, then you will start with the veto, that how veto has led to a situation, or how the provisions of Security Council gives, UN Charter gives Security Council much more power than the General Assembly, which is more reflective of the democratic structure of the world rather than the Security Council. So those type of lines, and supported with articles. So do not write completely GS type. Article 33 provides for this, 34 provides for this, right? And then you do the criticism. ठीक है, इसको पूरा GS नहीं बनाएंगे, थोड़ा सा somehow law also is required. सर ये कोर्स है, अरे you ask Aman the this क्या नाम, Anjali, okay, you call and ask Anjali. Yes, Maitri, very good example can be given. Okay, now what is innocent passage? Again, this year the question was asked. In fact, if you go to the topper's copy, you will find every year I ask this question: innocent passage and hot pursuit. There are two topics, either one of them comes, right? So what is the heading? First, can clause so and so provides for innocent passage? Meaning of the word innocent, meaning of the word passage, condition governing innocent passage. So these will be three headings and content in it. That's it. Nothing else. Similarly, let us come to 3C, territorial sovereignty. कैसे होता है, right? So basically it actually talks about how the state is recognized. See the question has been sort of they have tried to make it new, but sovereignty is one of the aspect of your recognition. Your recognition means you are sovereign. Okay, so basically they are talking about theory of recognition. Basically they are talking about theory of recognition. You have to talk about these two theory of recognition. So right, understood? So that is something you can talk about. क्या पूछा आपने? नहीं नहीं अमन, ऐसा नहीं कहा, मुझे पता नहीं है. आई एम सेइंग दैट we discuss कर लेते हैं. Let me discuss the questions. This is the administrative issue. You can call the institute. ये मैं कह रहा हूँ. Okay. चलिए, तो let us come to 7A, definition and meaning of nationality. हाँ भाई मैत्री, और भी कोई यहाँ पे टेस्ट सीरीज का स्टूडेंट है या ऑप्शनल का? यस, एनीवन इज हियर? बताइए फिर. लेट मी, दो तीन नाम तो मुझे दिख भी रहे हैं यहाँ पे. यशस्वी, आई थिंक यू आर आल्सो वन ऑफ द स्टूडेंट. यस, टेल मी व्हाट इज द थ्योरी ऑफ नेशनलिटी. दो थ्योरी हैं. कैन एनीवन टेल मी द थ्योरी ऑफ नेशनलिटी? ठीक है, मोड्स ऑफ एक्विजिशन वही इंडिया वाले हैं, राइट. इसमें स्पेसिफिकली मैरिड वुमेन का जो कन्वेंशन है वो मेंशन करना हो. ठीक है, मैरिड वुमेन का कन्वेंशन. एंड आल्सो द डिस्टिंक्शन बिटवीन नेशनलिटी एंड सिटीजनशिप, राइट. सो नेशनलिटी इज समथिंग, सिटीजनशिप इज मच मोर broader word than the nationality. ठीक है, yes, convention on very good. Now let's come to 7B. हाँ, वही है. That is the theory of nationality. There are two theories, either by territory or by blood, and it will mostly governed by the municipal constitutional law of a particular country. And then you go on and talk about these are the four methods. And then especially with regard to married women, you have to talk about the married women. The convention says married women must be given a right to either acquire the nationality, a choice, sorry, either to acquire the nationality of her husband or her own nationality. ठीक है, so nationality should not be taken up in away merely because he is married, right. So that is something you have to citizenship. I have to talked about citizenship is much more broader word than nationality, right. Nationality is a word which is recognized in international law. Citizenship is something with municipal domestic constitutional. Yes. Now let's come to 7B. Discuss the right of the state to formulate reservation. ये क्वेश्चन मैंने पूछा था, what do you mean by reservation and what are the provision governing reservation. ठीक है, the same thing है. We have to first talk about definition of reservation. क्या है definition? Yes, मैत्री बताइए कि reservation is a which statement? Reservation is a unilateral statement. ठीक है, given by the state party which affects rights and his rights and obligation vis-a-vis that particular treaty. ठीक है. Okay. Then what is the legal effect of such reservation? So there will only that is only something. तीन चीजें होती हैं रिजर्वेशन में. पहली कि it only affects your right and duties. Second, it will be allowed only when it is permitted. Yes, Akshay, correct. It is permitted under the VCLT provision. If not permitted under that treaty, the reservation not allowed. And modification is governed separately. ठीक ना, तो ये तीनों प्रोविजन अच्छे से आप मतलब एक्सेप्टेंस, मॉडिफिकेशन एंड गिविंग ऑफ रिजर्वेशन, दीज ओनली थ्री थिंग्स. यस, वो तो just cogent norm or the reservation में ये भी provision है कि where you cannot violate the core of the treaty itself, right. Okay. Explain most favored nation and national treatment principle. There are two principle WTO का national treatment and most favored. Simply explain them with one case laws. इसमें तो इंडिया के भी केस हो सकते हैं, right. Like if you remember 2 years before there was a question with regard to this solar panel case which India lost the case. ठीक है, like in the case of national treatment principle, what is this principle? Basically it says if a particular product entered into your territory. So whatever tax you want to take, you take on the border itself. Now, once you enter the territory, every product would be considered same. It means that based on its origin, you cannot differentiate between products. That is the national treatment. Okay? Now, this national treatment, remember, one of the exceptions is government procurement. Now, India came up with a provision, with a scheme. If you produce solar power, I will purchase solar power. But one of the condition was that solar power from which you are generating electricity must be manufactured in India. Okay, that was the yes question. I mean case. Now India lost that case in WTO, and the primary concept was this government exception would not apply because you are procuring electricity, but you are indirectly differentiating between your this solar panel, and solar panel and electricity are not like products. Okay? So it means that you can only and only make an exception with regard to government procurement when it is a like product. ठीक है, same trademark वाला case, right? कि how do you consider something to be a like product as to avoid confusion. ठीक है, so those example could have been given very easily. Okay. Similarly, let us come to 8A. Critically examine the development or use of nuclear weapon with a special focus on treaty on prohibition of nuclear weapon. Repeated question. Last year, discuss the effectiveness of 2017 treaty. They have asked, right? Exactly same. ठीक है, कोई difference नहीं है इसमें. Now here, if you remember, you have to take a much more broader aspect of the prohibition of this nuclear weapon treaty. They basically talk about complete disarmament. And one of the major provisions that cannot be any reservation and there is no end date to the treaty. Okay, so ये तीन बड़े important point है, right? It talk about complete destruction. ये ऐसा नहीं कहता आपको allow करेंगे उसको allow करेंगे. No, complete destruction. Second, there is no reservation. No reservation will be allowed. Specifically mentioned. It is hardly a 3-page treaty. Who is writing something? Please stop it. Annotation. How do I remove it? Anyone? Okay. Yes, so I have disabled the annotation for others. Okay, so that is something you can keep in mind, again, quite easy, right? Very easy actually. Okay, now let us come to 8B. What are the different type of asylum and make a distinction between territories? See, what are the type of asylum? These are the two type of asylum. So what is the meaning of the first question? Doesn't matter. So basically you have to talk about asylum mostly. When asylum 2 question comes, last year like they have asked asylum, when asylum and extradition starts. This year they have asked this. Next year again they will ask asylum and extradition starts. Right? So this is something odd. Sometimes they ask you principle of extradition, double criminality, rule of specificity. Like that, last year they asked you about the rule of specificity, if you remember last year question. Okay, so again very typical question, not a very tough thing. And 8C, the simplest and the most utilized mode of settlement is negotiation, which does not involve a third party, unlike mediation. Discuss which of these modes is best suited for the settlement of international dispute. The question that I asked in the test series, we discuss the various method of peaceful settlement of dispute, and which do you think is the best suited? That was our question in test series, but they have asked here, talk about negotiation in detail, and then talk about, yes, correct, and then talk about which is the which mode is best suited. So obviously when you are writing about negotiation, you have to talk about negotiation is best suited, right? Plain and simple. Okay, now overall my feedback questions is very easy, really very easy question. There was no question which is surprising. And one thing I always tell those who are thinking of taking law optional, that do not read too much substantial fundamental right. Not required. Like those who are in our batch, right? They must be knowing, I think Abhishek or Adesa is there. Yes, Adesa, if you remember, I told you in the class. The entirety of the fundamental right I will complete in 1 week. 1 day 12-13. 1 day interrelationship between fundamental right and DPSP. And 3 days with regard to the entire fundamental. So don't ask question. ठीक है, इस साल में देखिए सिर्फ एक क्वेश्चन पूछा. ठीक है, लास्ट ईयर भी सिर्फ एक क्वेश्चन था 10 मार्क. राइट, तो जो सब्सटेंशियल फंडामेंटल राइट है उसमें सी द प्रॉब्लम इज our university system is based something like that. एक सेमेस्टर में पूरा फंडामेंटल राइट पढ़ाते हैं, एक सेमेस्टर में एवरीथिंग एल्स. And that is why the problem arises कि students start to read like in MPGN also 50% of MPGN is fundamental right. Would you agree, all of you? 50% of MPGN is fundamental. एक क्वेश्चन आना है, ठीक है, नॉट रिक्वायर्ड, लीव इट, नॉट रिक्वायर्ड, ठीक है। सो दैट इज व्हाट यू नो आई टेल ऑलवेज कि फंडामेंटलाइट मत पढ़िए, ठीक है। इनफैक्ट इसमें तो चैट वो व्हाट्सएप नहीं चलता, अदरवाइज सो यू मोस्ट ऑफ द स्टूडेंट एट द लास्ट टाइम व्हेन दे आस्क कि सर क्या पढ़ें कॉन्स्टिट्यूशन में, फंडामेंटलाइट छोड़ के सब पढ़ो, ठीक है, डोंट रीड फंडामेंटलाइट, ठीक है। दैट इज समथिंग यू नो दिस ईयर आल्सो होल्ड्स ट्रू, लेकिन वही हो सकता है कि सम ईयर दे माइट आस्क 50 मार्क्स ऑफ फंडामेंटलाइट बट दे नेवर आस्क, ठीक है। इस बार भी सब्सटेंशियल का बस एक केस था, पिछले बार आई थिंक 29 भी पूछा था, राइट, वन क्वेश्चन वाज ऑन 29, दैट्स इट, उसके अलावा कुछ नहीं पूछा था, right? So something that is what you can take into account. चलिए, so this is something we have talked about paper 2, दो एक दो दिन और मुझे समय दीजिए, right? Then I will discuss, right? Paper 2 also I will discuss, not to worry, क्योंकि paper 2 I think was little bit trickier than paper 1, ठीक है। Same link could be there, right? I will reorganize the link. Paper 2 I will discuss after that. चलिए, now any question you have, please go ahead and you can ask me, otherwise we will wind it up. Yes, anyone, and don't ask me with regard to paper 2, that I will go on separately. Any questions anyone have, please go ahead. Yeah, this is a very typical question, Priyansu. In case law, like in this paper, if you talk about GS type questions, almost no case law. But if you talk about Article 21 question that we have with regard to live death, in that even it is a 10 marker, you could write 3-4 cases. Okay, so that actually depends what kind of question you have. But as a benchmark, you can talk about 2 cases in 10 marker, 15 marker, 3-4 cases, and 5-6 cases in 20 marker. But again, if you have a GS type question in 20 marker, no case. Okay, Priyansu? So a general framework you can keep in mind. Yes. You can do, ठीक है, you can, if you want, you can, or you can finish the syllabus then join, that is also okay. ठीक है, मोस्टली मैं ये एडवाइस करता हूँ कि गिव प्रीलिम्स एंड आफ्टर प्रीलिम्स यू कैन ज्वाइन, बट ऑब्वियसली जैसे someone else, Palak Jain, not the one who is attending it, she wrote last year also without qualifying prelims test series, and after qualifying also she wrote, ठीक है। तो that depends what kind of practice you need. Okay, Priya, so accordingly you take the decision. Yes, Amisha, so what date we can expect the solution book available in de facto website updated? मेन सब एक हफ्ते मान लीजिए, एक दो हफ्ते अराउंड, हमेशा एक दो हफ्ते। मैं तो सोच रहा हूँ दो बिना हमेशा, क्यों? क्योंकि प्रॉब्लम क्या हो रहा है हमेशा, आई एम टेलिंग यू, इफ यू लुक एट 2014 ना पेपर, so 24 पेपर, वहां पे मैंने ऑलमोस्ट 50% में लिखा था कि लुक एट 2013 दिस क्वेश्चन। इस बार भी वही करना हो, ठीक है, बिकॉज देयर सो मच क्वेश्चन व्हिच इज रिपीटेड, ठीक है, कि हार्डली देयर आर 4-5 व्हिच इज न्यू, at least in paper 1, Anisa. Understood this point? Like if you look at that book also, there also, I have talked about that how, this has been, from go and see this question, this question, this question. ठीक है, so same thing happen here also. Why, when the 15th September batch will conclude? अच्छा, ये 5 महीने, 4.5 से 5 महीने. Subham is one of the candidate. I mean, last year का इसका syllabus खत्म भी हो गया. You can talk to him, right? He will give you better feedback. Okay, Anisa. सर 2028 के लिए लॉ ऑप्शनल बैच, 28 तो बहुत दूर है अमन, आप थोड़ा सा वेट कर लें, 27 में ट्राई कर लें। देखिए, इस बात पे डिपेंड करता है कि आपको मेंस कब देना है, प्रीलिम्स मतलब कब लिखना है। तो मान लीजिए आप 28 का प्रीलिम्स लिखना चाहते हैं तो 27 के मिड के अराउंड आप ज्वाइन करें, दैट इज मच मोर बेटर। नहीं नहीं, बीएनएस तो वंदना, दैट इज द क्वेश्चन दिस ईयर आई आल्सो, दे हैव नॉट आस्क्ड बीएनएस, दे हैव टॉक्ड अबाउट ओनली आईपीसी, ठीक है, बट स्टिल in introduction you write IPC/BNS, that will be helpful. No, it doesn't happen, Akhilesh. Don't worry about it. Initially, the toppers, even the good toppers used to take 5 years, for 5 months, 5 hours, 4 hours in the initial 1-2 test. And once you go follow with the handwriting, it reduces to 3 years. I mean, 3 hours, right? Don't worry about it. शुरू में दिक्कत आती है। सारे यहाँ यूपीएससी वाले हैं अमन, राइट? मैं कुछ और कह रहा हूँ, मैं कह रहा हूँ कि 28 अगर आपका अटेम्प्ट है ना, तो आप 27 के राउंड यू ट्राई फॉर लॉ, ये मैं कह रहा हूँ। मैं यूपीएससी पढ़ाता हूँ और कुछ नहीं पढ़ाता हूँ, ठीक है, ओनली यूपीएससी। ओके, शेयर रिसेंट टॉपर आंसर कॉपी। अभी रिसेंट टॉपर सब ऑनलाइन है, इट इज देयर ऑन द साइट, यू गो टू द दिस website, right? defacto.in, it is already there, you can download it, freely downloadable. Okay, we should start. Yes, Pranjal, very correct. फुल फॉर्म मत लिखिए, कभी नहीं लिखना, आईपीसी बीएनएस चलेगा, ठीक है। Any essential of law answers? Adesa, I think you are one of the student, right? अच्छा, नो, तो कोई और है देसा, ओके, ठीक है। तो ये तो मतलब दिस क्वेश्चन आई हैव टॉक्ड अबाउट आल्सो, राइट? एसेंशियल ऑफ लॉ ऑप्शनल, इंट्रोडक्शन में आप एटलीस्ट 3-4 लाइन लिखे, स्ट्रक्चर ठीक रखे, प्रेजेंटेशन अच्छी होनी चाहिए, आई हैव टॉक्ड अबाउट वेरी डिटेल है देसा, राइट? ठीक है, फिर भी इफ यू हैव, आई थिंक यू आर टेस्ट सीरीज स्टूडेंट, आई थिंक, राइट? स्टिल यू कैन आस्क मी, ठीक है मैम, हेल्प कर दूंगा, दैट नॉट एन इशू। आंसर्स लिखिए दिशा, दैट इज द ओनली थिंग, ट्राई राइटिंग आंसर्स, खासकर जो मैं वीकली क्वेश्चंस देता हूँ ना फाउंडेशन में, उसको जरूर लिखिए, दैट इज वेरी हेल्पफुल। उसमें फिर आई विल गिव यू कमेंट्स ऑल्सो ना। मैं समझ गया। तो वीकली आंसर्स तो दिशा आपने साथ कुछ ही लिखा है, एक दो लिखा है, ज्यादा नहीं लिखा। उसको लिखिए, वीकली आंसर्स लिखिए दिशा, वेरी इंपॉर्टेंट, ठीक है, दैट विल रियली हेल्प यू अलॉट। चलिए तो वाइंड अप करें, और कुछ क्वेश्चन नहीं हो तो एवरीवन लेट अस वाइंड इट अप। ओके, यस सर। ये किताबों के लिए मैंने बड़ा अच्छा एक वो लिखा हुआ है, राइट, आपने उसको देखा नहीं? अच्छा, मैं एक चीज दिखाता हूँ आपको, देखिए जैसे डी फैक्टो के वेबसाइट पे आप जाएंगे ना, तो यहाँ पे बहुत अच्छे तरीके से मैंने ना सब कुछ बताया हुआ है। लेट मी नो सॉर्ट ऑफ शेयर विथ यू आल्सो फॉर अंडरस्टैंडिंग। देखिए ये इनका वेबसाइट है। यहाँ पे आप कुछ मत कीजिए, से ये जो यहाँ पे जाएंगे ना, ये फ्री रिसोर्सेज में, ठीक है, और जस्ट स्टार्टिंग में जाइए आप बुक्स, ठीक है। तो जैसे अगर आप इसमें जाएंगे तो मैंने टॉपिक बाय टॉपिक बताया है कि क्या फॉलो करें। जैसे इंटरनेशनल लॉ, तो इसके लिए ये फॉलो कर लो, इस दोनों के लिए स्टार की बुक फॉलो कर सकते हो। जैसे ये डिफरेंट पीसफुल सेटलमेंट ऑफ डिस्प्यूट, कुछ नहीं करना है, ये यूएन का ये हैंडबुक है, इसको पढ़ लो। इस हैंडबुक में इतना ज़्यादा सफिशिएंट मटेरियल है कि इसके बियॉन्ड कुछ नहीं करना है, फ्रीली पीडीएफ अवेलेबल। और ये यूएन का ही हैंडबुक है, ठीक ना, नाम ही है इसका हैंडबुक ऑन पीसफुल सेटलमेंट ऑफ डिस्प्यूट, ठीक है। अब इतना बड़ा हैंडबुक है, बस खाली तुम उसका नाम याद कर लो, मेजर मेजर क्या है। फिर आप आगे आ जाओ। इसके लिए टॉपिक नंबर 10 स्टार्ट से ले सकते हो, लीगलिटी ऑफ यूज ऑफ न्यूक्लियर वेपन, ये पीडीएफ से सफिशिएंट हो जाएगा, ठीक है। तो मैंने जो है ना टॉपिक बाय टॉपिक पीडीएफ दे रखा कि ये पढ़ लो, दैट इज मोर देन सफिशिएंट, ठीक है। तो इसको थोड़ा सा आप वंस यू विजिट इट है, जैसे कुछ कुछ टॉपिक ऐसे, ये देखिए लोगों को इसमें प्रॉब्लम होता है, सेल्स ऑफ हायर खर्च, तो ये 4 पीडीएफ है, इसके बियॉन्ड कुछ नहीं पढ़ना, ठीक है। तो जस्ट गो थ्रू इट, मोर देन सफिशिएंट है, ठीक है। तो आप वेबसाइट पे एक बार खासकर इसको डेस्कटॉप पे खोल के ना बड़े ध्यान से इसको देखो ना, वन बाय वन, ठीक है। तो फिर आपको अच्छे से समझ में आएगा कैसे करना, ठीक है, दैट विल बी क्वाइट हेल्पफुल। वही मैं कह रहा हूँ अमन, कि आप वेबसाइट को एक बार खोल के जो है ना बड़े अच्छे तरीके से लाइन बाय लाइन देखिए, बहुत डिटेल गाइड है, टॉपिक बाय टॉपिक क्या पढ़ना, वो भी मैंने पर्सनली लिखा है सबको, ठीक है। तो बड़ा अच्छे से आपको हेल्प करेगा। चलिए ठीक है, पेपर 2 का डिस्कशन लेते हैं हम लोग एक दो दिन में, आई विल प्लान एंड वी विल इन्फॉर्म यू एंड दैट ग्रुप इटसेल्फ। ओके एवरीवन, चलिए देन, थैंक यू एवरीवन, ओके, थैंक यू।